Okay, here we go. Giant twist tonight in the Wall Street sex slave scandal, the one we've been covering from the very beginning. This twist is different. I think it's pretty significant. The ex-JPMorgan Chase banker who accused a female executive of turning him into her office sex slave is now trying to scrap his bombshell New York State lawsuit and start all over in federal court. Yeah. The plaintiff, ex-banker Trey Rana, filed a motion Monday asking a Manhattan judge to dismiss his lawsuit against JPMorgan Chase and executive director Lorna Hardini, allowing him to pursue this matter in federal court instead. Why? We'll talk about it. Now, Rana's new legal team claims that the original suit against Hardini left out crucial federal violations, including race discrimination, harassment, retaliation, as well as interference with family and medical leave. And in the documents filed Monday, they say the full airing of grievances should now take place in federal rather than state court. Rana's attorney saying, quote, the public has been fed a wildly distorted version of this case manufactured from sensational headlines that bear no resemblance to what actually happened to Mr. Rana. The full scope of racism, abuse, and retaliation he endured at JPMorgan has not been told, unquote. Now, Rana's lawyers also claimed to have uncovered substantial new evidence. What is it? Are they going to provide texts, emails, videos, photos, anything backing up the claims? Also, why go the federal route? Lorna Hardini, to be clear, denies all the allegations, has filed a defamation countersuit against Rana. JPMorgan spokesperson says the firm supports her right to defend herself, that an internal JPMorgan investigation found no evidence to support Rana's claims. A lot to come up here. Joining me now in the studio, trial attorney, litigator, legal analyst, my friend, Richard Soenstein. Good to see you, sir. Why go the federal route, and why go now? I mean, unless he discovered something new, which I'd be questioning where did he discover it from? Why go now?
So I was surprised the case wasn't brought in federal court in the first place, because these things, discrimination, harassment, retaliation, they're illegal under federal law, state law, and city law. And in most cases, as long as your claims are timely, you can bring those claims in federal court, and you bring the state claims and the city claims with them. And please don't tell any of the state court judges I appear in front of I said this.
Nobody, they won't watch this.
Good. Federal court is better.
Right, because it can be quicker, the rules are different, right? You won't necessarily get a bigger payout.
No, in fact, that's one of the things about it. There's some argument that the payout is less in these kind of cases than federal cases, but they're quicker, there's more discovery, the judges are more attentive, the courtrooms are nicer.
If I was his attorney, given all the public attention, if they file a federal complaint, don't they have to include at least one text message, one email, something to say he's telling the truth?
No, not
one text message of her saying, hey, come on over?
I mean, I would do it, especially in this case where her defense is that none of it is true and that there's reporting like we're doing, testing the veracity of it. I probably would put some evidence in there, but you don't have to. You just have to allege facts.
What is this substantial new evidence that they claim they have?
I don't know.
That's it?
I don't know. How do I know? You know, he has new lawyers, right? There was some issue, I think, with the prior lawyers. He's got new lawyers. Right. They have a different strategy. The new lawyer's strategy is federal court. Maybe for some reason the old lawyers didn't want to go to federal court. Maybe it had to do with where he brought his claims in the first place, if he brought them to a state agency or a federal agency.
Here's the thing. People look at this and say these claims are so salacious. No woman talks like that the way that she's accused. He's represented by a big firm. They wouldn't go forward with a frivolous lawsuit, right? They wouldn't go forward unless they believe there's something there.
Well, the thing about that, Jesse, is that all of the parties in this case have lawyers. The defendant has a lawyer, the bank has lawyers, and so somebody in this case is lying, not just a little bit. Somebody is lying a lot, and every single one of them has lawyers. The fact that you have a lawyer doesn't mean you're telling the truth.
You got to make sense of this First Amendment argument. So they say, his lawyers, some or all of the statements at issue are not actionable under the First Amendment and New York law because they constitute statements of opinion or rhetorical hyperbole. Let me explain that. Because she sued him for defamation, and we talked about this before. She's not suing him for defamation for the claims that he made in the lawsuit, because that's protected. She's suing him for the allegations that, if I'm understanding correctly, the allegations that he made in an internal complaint in the company. So what are they saying? That he was exaggerating? Because if you're making claims, she sexually assaulted me, she harassed me, she said racist comments, those are like statements of fact. What am I not getting about this First Amendment argument?
I think you're right, because that quote you just read is saying some of the statements at issue weren't statements of fact. Some of them were statements of opinion. Some of them were hyperbole. Probably some of them aren't actionable. But at its core, they seem to be statements of fact about what she allegedly did, which could be actionable if they are false and if they weren't made in a court pleading.
Strange, right? It's an interesting argument. I guess the question now is, so he wants to move this to federal court.
Yep.
She filed her countersuit, again, in state court. Is that separate, or does her defamation countersuit go to federal court too?
So assuming the state court allows him to voluntarily dismiss his claims and replead them in federal court, which I assume the state court would allow, because why wouldn't they?
Okay.
Then she's going to have the option. She can either keep her defamation claim in state court where it is, or she probably could bring it as a counterclaim in federal court. In fact, she might say, Judge, don't let him move the case unless I can also move my counterclaims with it. And it depends on her strategy. Does she want that? I mean, for judicial efficiency, it should all be heard together. But strategically, she may prefer to keep it in state court.
Gave me a lot to think about. This case ain't going anywhere. Richard Schoenstein, you're going to be on again. Thank you so much. Good seeing you.